and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Child Labour Prohibition and Regulation Amendment Bill 2012. To discuss the issue, I have with me Mr. P. Joseph Victor Raj, National Convener, Campaign Against Child Labour, CACL. Dr. Preet Rustogi, Professor Honorary Secretary, Indian Society of Labour Economics. And Professor S.C. Srivastava, Secretary General, National Labour Law Association. Now for the headlines. The Child Labour Prohibition and Regulation Amendment Bill bans employment of children. The bill defines adolescent and prohibits employment of adolescents in work considered hazardous. The Parliamentary Standing Committee on Labour and Employment recommends regulating working conditions and wage criteria for adolescents. The Child Labour Prohibition and Regulation Amendment Bill prohibits employment of children below the age of 14. The bill defines adolescents and prohibits employment of adolescents in work considered hazardous. The parent may be pulled up if it is found that they have allowed violation of the provisions.
The objective of the amendment bill is to ensure complete prohibition on children below the age of 14 years working outside the family. According to the bill, children from the age of 14 to 18 years will be prohibited to work under hazardous conditions. These amendments in the existing law are likely to synchronize the right to education and juvenile justice law, minimizing chances of children doing anything else but study.
See, in light of the Right to Education Act, the amendment was due right from 2009. When we said that all children below 14 should go to school, we were bound to amend the Child Labour Act and say all children below 14 should be going to school. So it's a welcome move, at least because it brings a complete ban on child labour up to 14 years. But with some concerns related to children working in family employments, in terms of children in the age group of 14 to 18, the whole definition of hazardous being very narrow. There isn't much that has changed about rescue and rehabilitation and enforcement of the Act. So we have concerns about the Act, but it's about making the enforceability and the content of the Act stronger, because we are bringing a new amendment after 29 years, and if we leave these loopholes even today, it's going to be a cost to children.
According to the Child Labour Prohibition and Regulation Amendment Bill 2012, adolescent is defined as a person between the age of 14 years to 18 years. The bill does not allow adolescent engage in hazardous occupation. The definition of child has been amended to a person who has not completed 14 years of age. The proposed changes in the existing law may allow a child to help his family after his school hours in family fields, home-based work, forest gathering, etc. The child is allowed to go to the technical institution for learning purpose only. The bill empowers the central government to add or delete any hazardous occupation and process. It enhances the maximum punishments from the existing imprisonment of 1 year to 2 years. The bill also enhances the maximum existing fine of 20,000 rupees to 50,000 rupees.
Problematic area is where there is a proviso in the bill which allows children to work in family enterprises and the entertainment sector after school hours or during vacations. Now the entertainment sector is large. There's there's so much that comes under it. You could be looking at spas, massage parlors, children who are made to perform in restaurants, whether it's in the name of folk music or folk dance or whatever. So entertainment is really large. We need to look at it very seriously.
The amendment empowers government to grant powers to the district magistrate to ensure that the implementation of the proposed legislation is carried out properly. The bill also empowers the government to make inspection at places where the employment of children is prohibited. The amendment bill was introduced during the UPA government.
Although the amendments in the Child Labour Bill are welcomed and are being considered beneficial for the overall development of the child, But the implementation of the law, monitoring and creating awareness in parents and the employers of the children are some of the biggest challenges which the government might face. With cameraman Shivam, Dipali Pandit for Rajya Sabha Television.
The parents or guardians of children and adolescents will not be liable for punishment unless they permit children or adolescents to work in contravention of the provisions. So my question straight away first to you. Parent, should they be pulled up? And especially given the way India is, it's not just Delhi, we are looking at India and a lot of people who are not as educated as they are expected to be, who will probably may not have the information that they are doing the wrong thing.
Yeah, well, I think, let me answer this question. See, the first thing is, what the law provides is that, see, so far as the parent is concerned, for the first offense, he is not punishable. But for the subsequent offense, the penalty is up to 10,000 rupees. This thing I want to make it very clear. And secondly, in the present setup, in the social scenario, unless until we provide some social security, and in the social context, I think it is necessary that we must take up the point of view of the parents themselves. And therefore, what is required in the law is that for the first time, there is a compounding of offense and they say he is not punishable. But for the second and subsequent offense, he is punishable. So therefore, in the social context, I think it is desirable that some latitude must be given and for the first time.
So would you like to add on that point, because that is what you were suggesting, that they should completely be given a blanket relief and not be included at all?
Yes, actually the parents should not be punished for permitting the children to work. That's what the Act says now. As you know, the children may not be always under the supervision or under the control or under the protection of the parents. There are a lot of street children, there are a lot of missing children, and the parents may be in another town and the children may be in another town. And if the child is working and if you are going to victimize the parents, it is not fair.
Okay, that's the point. So there is a finer distinction. What about children who are not directly being regulated or controlled by their parents, who are not with their parents?
Yes.
What do you do with them? Eventually, they can't be faulted for that.
Yes.
Ma'am, anything that you would...
I would just like to say that as a legal provision, it's important to send the right message. And since legal provisions are also a signal to what is desirable, it's important to send the message home that children are not for use in labor processes. And they are to be in education, and their self-development implies that they should not be doing work of such nature that affects their overall development. And that's the basic frame of our being against child labor. So if we agree with that, then no child should be working. That's a desirable. But there are circumstances under which parents might end up using child labor. The message has to be that children are not the property of parents to use for their economic gain. So as far as that message is concerned, I think it's important to have a proviso, because if we don't have a proviso, like you said, we are not talking about only metropolitan cities, we are talking of remote areas, backward areas where the message is not clear. While we agree that parents will think of the children's good, it's not always the case. We know of the extent of child abuse in the country. We know of all the other contexts. So given that, this is important.
So another point that was raised was when the CRC, which is the point made by ma'am, Convention of Rights to Child, that's the UN convention.
Sure.
When that convention clearly states that 18 and below are children, then why are we creating, what is the need for us to create another category known as adolescents?
Well, I think we have to look even the worst form of child labor, which is 182 Convention of the ILO. That provides itself that no child up to 18 years should be permitted to work in a hazardous occupation. I think this is a step towards that we want to achieve, because so many countries, most of the countries have ratified the ILO Convention 182 on the worst form of child labor. We have not yet signed on that. In order to do this thing, what is required is that such a provision must be inserted in the law, and it is a step towards for achieving the same.
So you saying that it is more important for this law to be in synchronization with the ILO provision than for it to subscribe to the CRC?
Yeah, I think this is the major thing, because there are two conventions which are very extremely important. One is
and they are complementary, not contradictory.
138, and the other is 182.
So these two, ILO and CRC, they are not contradictory, but they are complementary.
Yes, yes.
Do you agree with that, sir?
No, actually, I mean, UNCRC, even the first clause, it states that any person below the age of 18 is a child. Then we have ratified it some 23 years back. And after that, we should have synchronized and harmonized the definition in all the legislations. But we have failed to do, I mean, in the past 22 years, because only around 5 legislations have the definition, like, I mean, any person below the age of 18 is a child. And the recent National Policy for Children 2013 also defines that any person below the age of 18 is a child. So after that, I mean, instead of harmonizing the definition, if we are going to create more confusion, it's not fair. So here the definition should be like, I mean, any person below the age of 18 is a child. That's how we should bring the definition.
So it should be simplistic and should not be complicated by bringing in another category. On the relief and rescue and rehabilitation.
Okay.
What's the issue with the bill?
Actually, I mean, right now, the law says that, I mean, they will be rehabilitated as per the existing legislations. But instead of a vague definition like this, I mean, that also should include compensation for the, I mean, the children who are rescued, I mean, reparation and repatriation, and also proper rehabilitation measures. We cannot, I mean, the law doesn't even say, like, as per which law they will be rehabilitated.
Time for us to head into a break. When we come back, we will talk about the recommendations of the Standing Committee on working conditions and wage criteria for adolescent workers. Welcome back. The Parliamentary Standing Committee on Labour and Employment in its report recommends including the regulation of working conditions and wage criteria of the adolescents. This is recommended as there was no provision to regulate the conditions of service of adolescents.
The Parliamentary Committee is of the view that adolescents should complete their elementary education before being allowed to any kind of employment. The committee wants the government to amend the bill to delete the provision of allowing a child to help his or her family after school hours, as the committee believes that allowing children to work after school may affect their health.
There needs to be zero tolerance for allowing children, below the age of 14. I think the fact that they introduced this bill without this amendment was a big step forward, towards banning child labor, at least below the age of 14. But now with the introduction of this proviso, for whatever reason, I think they've diluted, children's right to a life of dignity and education.
The Standing Committee recommends that children below 14 years of age should be in school, and those children who are above 14 years of age who miss school should at least complete elementary education. The committee recommends that the definition of hazardous processes needs to be widened and should include safety, health and morals of adolescents in it. The parliamentary panel suggests that the provision of allowing children to help their parents in domestic work should be reframed. It is of the opinion that poor parents of children who work to fulfill their basic needs should not be punished. The committee recommends that the employers who exploit adolescents should be covered under the punishment clause. The Standing Committee suggests that vigilance and monitoring committees should review the implementation of child labour law periodically, and that a comprehensive strategy to save poor children from exploitation should be made.
For 14 to 18-year-olds, we do need to have regulations, particularly if we're allowing them to be working in certain non-hazardous sectors. But at the same time, the definition of non-hazardous needs, or rather hazardous, needs to change. It's taken years for India to reach a stage where we have a list of 83 occupations and processes which are recognized as hazardous for children, which includes domestic work, it includes working in dhabas and restaurants, it includes many things beyond the factory area. And the present bill reduces that list to just 3. from 83, it has been reduced to 3. And that's a very, very serious concern.
The Parliamentary Standing Committee feels that no provision for rescue and rehabilitation of children are there in proposed amendment bill. So the government should have a new child labour policy and machinery to implement laws, policies and projects. The Standing Committee on Labour and Employment presented its report on the Child Labour Amendment Bill on the 13th of December 2013.
The Parliamentary Standing Committee on Labour and Employment has recommended quite a few changes in the bill, such as widening the definition of hazardous processes, reframing the provision of allowing children to work in the family, exemption of poor parents, etc. Apart from that, the committee has suggested the government to come up with a new child labour policy to implement laws, provisions and projects. With cameraman Shivam, Dipali Pandit for Rajya Sabha Television.
The committee recommends that provision should cover any place where employment of children is suspected and employment of adolescents is prohibited. Definition of hazardous, ma'am. That's a big challenge. Reducing it, as ma'am said on air, that from 83 to 3.
Yeah.
So that means you're virtually allowing the entire adolescent sector to engage in
All
almost
kinds of occupations.
all sectors.
Yeah.
So what's
That's going to be a very big concern, and that's one of the biggest issues against the legal provision as it exists today, because it's actually going in favor of using those adolescents for all the labor processes as it exists. So that is actually a very, very big thing, because how do we define what is hazardous? And the existing Factories Act is actually based on what is hazardous for adults. And that's where, again, this new category of adolescents is actually to, in a sense, put a cover on our thinking and our eyesight to treat the children different from the adolescents. To say that the adolescents are now ready to enter the labor force and work in all occupations which are okay for adults. So the distinction between children and adults is being smudged here.
And that's where the problem is, and the contravention of the CRC happens.
Yeah.
On the hazardous aspect,
Yeah.
there's a complete clear-cut dilution or the intent of completely defining it to such an extent that it limits the option of the adolescent child who, even if he wants to, can only work in completely safe environment and not ones that have been left out of definition.
Okay. Actually, the original 1986 Act did not come with this 18 occupations and 65 processes as hazardous. It is only after the demand by the child rights activists, the list was added over the period of this 29 years. And finally, now we have this 18 occupations and 65 processes. Now, if we are going back to just 3 occupations as hazardous, then the child rights activists have to fight and then increase the list. And also it's defeating the purpose of the past work the child rights activists have done. And also now they are, as she has already mentioned, the Factories Act, which is a legislation for adults, that is quoted here as for defining the hazardous industries. So whatever may be non-hazardous for an adult may be hazardous for children.
Correct.
So that has to be revised. Yes.
Sir, it's like giving from one hand or protecting the child or the adolescent with one hand and then slightly kind of taking away the protection from the other hand. Don't you feel so?
Well,
but there is a clause which says that the government, it empowers the government to be dynamic enough to add as many occupations as hazardous. So that right is there with the department.
Well, I think that there is a technical committee which looks into it, and therefore it is for the technical committee from time to time to recommend and add in the schedule itself. So I think this is not a one-time exercise. What is required in the law is the technical committee from time, they have to assess it and to find out which area which is not covered so far may be added in that. So therefore, there should be a monitoring committee, there should be a technical committee, a permanent standing committee itself.
So
which
what you're
may-
saying is that it's an evolutionary phase,
Yes.
and what has been identified need not be written in the bill.
That's right.
And it can be eventually built upon gradually by the government as the bill's implementation begins.
And that's why we have a schedule. The schedule is there. Only and we are going on adding and taking away from the schedule itself. So I think the schedule itself, we can add this thing. This is a formative stage. And the formative stage, I think something, the skeleton has been provided.
Ma'am, do you agree with that? It's an evolution.
Yeah, but just as, Victor was just saying that the entire child rights activists have
Worked
demanded and worked
have
and
moved it to-
decided, and there's a whole understanding of what is hazardous and which are the occupations which are likely to be most hazardous for the under 18s. So having done that, the logic of having a much shorter list almost implies as if the desire of the government or ministry or whoever is taking this decision is to have those adolescents available for tasks which were hitherto not allowed as it stood in the existing law.
Correct,
So that is why
So it's a
considered
dilution.
it's
It
a dilution.
appears as a dilution of the existing law. Ma'am, last word. So the sense of the whole thing is that somewhere or the other, the government is trying to make it implementation friendly by trying to, protect the parents who are probably not that informed or... so there is an effort to do that, and that's why these ifs and buts come in. That's the point of view of the government. That's what I feel. But then it dilutes the entire process and allows the parents and also the hazardous enterprises to do almost anything and get away with it. Correct?
Yeah. Technically, the hazardous occupations, no, because it does say that hazardous occupations are not allowed. But the biggest contest I have with this entire debate which we are having today is that it's not in favor of child rights. We are not thinking of the child as an entity who needs to be protected, provided development facilities and invested in as a nation. That's my biggest problem with the current provisions.
Moving on, my colleague Deepali Pandit spoke to Professor Shanta Sinha, former chairperson, National Commission for Protection of Child Rights, and tried to get her point of view.
Ma'am, how do you see the amendments in the child labour bill?
See, on the face of it, the child labour amendment bill that is being proposed in the parliament looks very radical because it brings into harmony the Right to Education Act and abolition of all forms of child labour up to 14 years of age. It also extends the act up to children in 18 years of age, and it criminalizes employment of children because earlier it was not a criminal act. So in that sense, I think it is radical, but then the devil is in the detail. So to give you an example, while they abolish all forms of child labor, they say that it is all right for children to work at home or during vacations before and after school hours. Now that I think is very retrogressive because we know that many of the children who work at home are not working like how they help me in my family, in my house, but they work on rolling of BDs, on sticking bindis, on making bangles, on doing embroidery, on doing chicken work, on making chappal, on many of these activities in an informal sector. It's a back-breaking work. It damages your eyesight, and it's completely in violation of child rights. They don't let the child play, they don't let the child have friends, and sooner than later you find that the child actually drops out of school.
Ma'am, there is no provision for the rescue and rehabilitation of children. What's your take on that?
I think what you say is right. I mean, it is so important that there was a provision about rescue and especially rehabilitation of children. Most acts which are criminal acts for children must also have a protection part of it, and that must be legalized and that must become mandatory, and that would have given greater strength, I think, but perhaps they didn't know how to combine a criminal act with a protection clauses in it, but certainly they have to have, at least in the state rules of the amendment, when they do that, that's very strong provisions on how children will have to be rehabilitated, and that rehabilitation has to be through education, because this is an act that harmonizes child labor and their release to their access to school and right to education.
Thank you, sir and ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.